My name is Sakim Akhtar. I'm the Administrative Director of the Program on the Legal Profession, and thank you again for coming to one of our weekly speaker series. We're pleased to have Stephen Meili here today. He's a clinical professor and supervising attorney for the University of Minnesota's Immigration and Human Rights Clinic. As many of you might know, the Program on the Legal Profession has a large initiative called the GLEE Initiative, the Globalization, Lawyers, and Emerging Economies. It looks at the impact of globalization on the legal profession, particularly in emerging economies. And we're lucky enough to have Steve here today talking about some of his research, which actually looks at the impact of international human rights treaties on asylum law in Australia, New Zealand, Canada, and the US, and the UK. And I think it's quite fitting that some of Steve's research ties in nicely to what we're doing in GLEE, and I think you'll thoroughly enjoy today's presentation. Steve Meili.
Okay, thank you. Hakeem, welcome everybody, thanks for coming. And first of all, I wanted to thank the Program on the Legal Profession and Harvard for inviting me to talk today. And also wanted to thank the National Science Foundation, which has, as well as the Robina Foundation, which provided funding for the study that I'm doing now and has helped to support the sabbatical that I'm on at Oxford, where I'm gathering the data on the UK portion of the study. Also want to thank the University of Minnesota Law School for giving me the sabbatical to gather the data that I'm going to talk about today. The topic for today, focusing really on 3 of the 5 countries that Hakeem mentioned, and that is the US, Canada, and the UK, and talking about the impact of international human rights treaties on asylum adjudication in those countries. Just as a point of reference, I was curious as to how many of you have some familiarity with asylum or refugee law. Have you taken courses in it, maybe involved in a clinic here? Okay, so some familiarity with it, but I'll go over some of the basics as well. And in terms of the roadmap of what I'll be doing today, we're talking a bit about the theoretical framework for the research. That is a brief review of some of the scholarship that's important in this area that informs the work that the lawyers are doing. Then I will give a brief description of the asylum adjudication process in each of the 3 countries that I'm looking at. I'll talk about the methodology of the study, how we're gathering the data, but I'll spend the bulk of the time on analyzing the data. And that's where I would certainly welcome your input, your thoughts, because I'm still in the process of gathering it and analyzing it, and would be anxious to hear what your reactions might be, because there are some phenomena that we're still in the process of both analyzing and trying to explain. And then offer some at least preliminary conclusions, particularly in terms of implications for US lawyers who represent refugees. And certainly I would imagine that some of you are thinking about that, perhaps actually already doing that in the clinical context. So I want to speak to that because, frankly, part of my interest in doing this work comes as a result of supervising the clinic at the University of Minnesota Law School, where students, like some of you, I'm sure, represent asylum seekers, people who are seeking refuge from persecution in other countries. And what becomes apparent very quickly is that when you do that sort of work in the US, you are limited in terms of the legal remedies. You're limited to what's called the 1951 Convention relating to the status of refugees, or the 1951 Refugee Convention. And that's pretty much the only weapon that you have in representing an asylum seeker and trying to get them refuge. What you find out in doing some research on this is that other countries, particularly the countries that I'm looking at in this study, Canada, Australia, New Zealand, and the UK, are more apt to use other human rights treaties in representing asylum seekers. And so what I wanted to do is to look at the circumstances under which those treaties are utilized in these other countries, how they may help or, in some cases, hurt asylum seekers, with the idea that perhaps we can start using those methods when we represent asylum seekers in the US, but also to contribute to the scholarly debate about the circumstances under which human rights treaties have an impact on state actors. That is, do they really matter? Because as some of you probably know from your courses, there's a debate out there about whether or not all these human rights treaties have any real impact. Are they do they actually influence the behavior of state actors, or are they just window dressing that allow states to feel good about themselves but don't really have any impact? And in fact, there's been some research to suggest that they can have the opposite effect, that they give some countries the cover to act even worse in a human rights fashion, because they can say that we've signed these treaties, and they can actually regress in their human rights protections. So I wanted to start out with a little cartoon that I think gets across one of the points that I've encountered in my interviews with a lot of the lawyers, particularly in Canada and the UK. This is a cartoon from the London Times about 10 years ago, where the use of human rights treaties and a human rights argument is a much more embattled area publicly than it is here in the United States, and for reasons that I'll go into during the course of the lecture. But here we have the senior attorney, or the barrister, who is talking to the junior, and says, if the law is on your side, you argue the law. If the facts are on your side, you argue the facts. The junior asks, but what if neither the law nor the facts are on your side? And then the barrister says, well, then you tell the judge it's a question of human rights. And the reason why this relates to what I'm going to be talking about today is that one of the themes that the lawyers articulated during the interviews that I've been doing with them is that they're concerned that some lawyers overuse human rights treaties, and that many judges, particularly those who are not particularly prone to accept human rights arguments, will see these arguments as desperate, that the lawyers have nothing else to rely on, and so they're throwing in the kitchen sink of human rights arguments. And so this is one of the ways in which those human rights-based arguments can hurt not just the individual client who's being represented, but the overall cause of the diffusion of human rights norms and the use of human rights norms in jurisprudence. Also, I think the cartoon relates to the who cares aspect of the study in terms of why it's important, because if we know the circumstances under which treaties can assist refugees, then lawyers can more effectively represent their clients, and policymakers can take the steps necessary to make those treaties more effective. All right, back to the roadmap. So I talked a bit already about the theoretical framework, which is really this debate in the literature about whether or not treaties matter, and trying to identify the circumstances under which they do. There have been some quantitative studies about this, but most of the evidence is anecdotal. And it also has to do with state treatment of its own citizens through torture, due process protections or lack thereof, anti-discrimination laws. And what I'm looking at is treaty effectiveness, but through the lens of asylum jurisprudence, which affects non-citizens. And also through a lens that looks at state actors, not so much legislators or executive branch members, but through the judiciary. That is people, the judges and the lawyers who appear before them. And asylum claims are a useful way to look at treaty effectiveness because asylum claims are so prominent. There's approximately 500,000 or so that are filed around the world every year. So there's really a vast array of quantitative data to be gathered through written opinions in asylum cases. So, and just to talk briefly then about the Refugee Convention, which I mentioned and which many of you are probably familiar with. But again, this is the main human rights instrument in the US for asylum adjudication. And under the Refugee Convention, you have to show, in order to get asylum, the client has to show that they have a well-founded fear of persecution if they are deported to their home country. But they have to show that that fear of persecution is based on one of 5 enumerated grounds. That is, their race, religion, nationality, a political opinion, or membership in a particular social group. If you can't show that you, as an individual, have been targeted for one of those reasons, then you're not going to be entitled to asylum. And so what I've determined through research is that, again, other countries, particularly the ones that I'm studying as part of this study, will use human rights treaties that offer broader protection. Okay? And so they're treaties that allow for the protection of refugees who are fleeing generalized violence, civil strife in a country where that individual may not have been targeted, particularly for retribution. So they can't fit within one of those refugee grounds, but they're nevertheless entitled to protection. And these treaties offer what is often called complementary protection. That is protection that complements the 1951 Refugee Convention. It's useful to analyze Canada, the UK, and the US in this context because they're among the most popular destination countries for asylum seekers around the world. According to the UN High Commission for Refugees, 15% of asylum seekers around the world in 2011 sought asylum in the US, which makes the US the #1 destination country. The UK and Canada each received about 6% of asylum seekers around the world, which puts them tied for 6th place. Each of these countries also have long-standing reputations for welcoming refugees to some extent and for honoring international human rights obligations, again, to some extent, but they are seen as leaders in this area. They're also good sites to measure treaty effectiveness and how lawyers utilize these treaties because they have ratified and in some cases incorporated several human rights treaties into their domestic law over the last 2 decades. Now, the asylum adjudication process is going to be very oversimplified, but it's actually quite similar in all 3 countries, which again is useful for this study. The initial decision in asylum cases is made by an administrative agency. In the US, it's the Department of Homeland Security. That initial decision can be appealed to an administrative tribunal, which in the US is the immigration courts and the Board of Immigration Appeals. And in the US, that's within the US Department of Justice. And then that agency, or the decision of that agency, that immigration court here in the US, can be appealed to an appellate court. And that's, again, true in all the countries, Canada and the UK. And judicial review is not of right. You have to seek it. And it's limited to questions of law, not to questions of client credibility and evidence. So the key for all 3 countries is that the initial decision is made by an administrative tribunal, and then that can be appealed to a court. And that's important for reasons that we'll talk about later. A quick word about methodology. The study is a mixed method approach. It's qualitative and quantitative. The qualitative is a series of, at this point, 60 interviews with lawyers in each of the 3 countries from different geographic regions within Canada and the UK and the US, open-ended interviews where we interview them about their use of human rights treaties and whether or not they think they're effective and why. And then the quantitative part of it is reading and coding about 6,000 written asylum decisions by administrative tribunals at first level and the appellate courts in each of the countries, and then coding them according to how the treaties are referenced. So we did word searches in a variety of case law databases for several treaties, and I'll get to the treaties in a second, but they're the treaties that the lawyers indicated are the ones that they use most frequently in their advocacy. And so we looked for treaty references over the course of the past 20 years. We chose a 20-year period because all of the key treaties that we've looked at have been ratified by each of the countries, the US, Canada, and the UK, within that period of time. But we also felt that a 20-year period would be sufficient to show any meaningful trends over time. Now, we're still coding some of the cases. So again, this is the results I'm going to show you today are preliminary. Here are the treaties that we're looking at. These will be familiar to many of you. And again, these are the ones that the lawyers that we have interviewed in each of the countries indicated that they use most frequently. And indeed, these are the ones that show up with some regularity in the decisions, and some more than others, and we'll go into that in a little bit. So the International Covenant of Civil and Political Rights, Convention on the Rights of the Child, Convention Against Torture, Convention on the Elimination of Racial Discrimination and Elimination of Discrimination Against Women. Now, the European Convention on Human Rights, obviously, not relevant in Canada or in the US, but utilized frequently by lawyers in the UK. And again, that's because it's an example of treaties that offer broader protection. Article 3 prohibits torture and inhuman and degrading treatment. Similar in some ways to the Convention Against Torture and certainly the Refugee Convention. But the advantage here is you don't have to show that you're going to be tortured for one of those reasons, your race, religion, etc. So again, it might be a situation where almost everybody is subject to torture. And if you can demonstrate that, you don't have to show that you've been targeted. So it's broader. Article 8 is treaty provision dealing with family life. And here, many people in the UK use that in situations where a person comes over, they may not have a valid asylum claim, but they come to the UK and they start to develop a family life. They marry a UK citizen, they have a child, they get a job, other indicia of family life. Then they argue that if you return mother or father to their home country, that's not going to be in the best interest of the child. That's going to not respect the family life. And so many people have been able to remain in the UK under that provision. It's very controversial. The government's trying to limit it. The tabloids have a field day with some of the cases under which people have been allowed to stay, including the person who was alleged to have received asylum because they have a cat in the UK. Not true. It was among the indicia of family life that the judge listed, kind of as an aside, but as any of you who have lived in the UK or know how the tabloids operate, they seized on that. And that man gets, and I forget what country he was from, but man gets asylum because of cat. And so that leads to a lot of the animosity, frankly, and the controversy over asylum in the UK that we don't have here for the most part in the US. All of these treaties have been ratified by each of the countries in the study, except Convention on the Rights of the Child, not ratified by the US. We are with Somalia on that, the only two countries in the world that have not ratified the Convention on the Rights of the Child. And of course, neither the US nor Canada have ratified the European Convention on Human Rights. Okay, so to get into the analysis of some of the quantitative data, what we're going to look at is the patterns of references to the treaties in tribunal and court decisions over the last 20 years. So we'll take each country individually first. Okay, so this is the UK, and the different colored lines are for the different treaties. So a few things that are quite noticeable about these trends. Again, this is as a result of doing word searches for the treaties, but also keywords and phrases from the treaties over the last 20 years. First of all, we see there are virtually no references to any of these treaties in the UK between 1990 and about 2001. And then we have this explosion, particularly in Article 3, and that's the one about torture and inhuman treatment in the UK in the early years of the 2000s. And the reason for that is that the UK passed something called the Human Rights Act in 1998. It became effective in 2000, and it effectively incorporated the European Convention on Human Rights into UK domestic law. So suddenly, the lawyers realized that they could now use Article 3 and also Article 8, and that's the orange line, not as big a spike, but certainly significant in their advocacy on behalf of their clients. Because many of the lawyers that we talked to in the UK said that the judges are very reluctant to rely on human rights law unless it's been incorporated into the domestic law. So once the Human Rights Treaty became part of UK domestic law, then the use of it increased. Now, we also see a tremendous drop-off after a bit of a spurt, particularly with respect to Article 3, and that's one of the phenomena that we're trying to explain. A few things have come up. We've talked to lawyers about this. We've talked to academics, and something that I think of as human rights fatigue, where courts will engage with human rights arguments for a while, but then that begins to drop off, and they're not as interested in those arguments. Or it's Catherine DeVerne, in some of her scholarship, has called it the learning effect. The judge is more likely to engage with international norms when those norms are newly relevant. So again, we have that drop off in Article 3. The only other treaty with any kind of significant references is the yellow one, which is the Convention on the Rights of the Child. And that we attribute to the fact that there was a decision by the UK Supreme Court in 2011 called ZH or ZH Tanzania. And in that case, the Supreme Court referenced the Convention on the Rights of the Child and held that any governmental official determining the fate of a non-citizen seeking refuge in the UK must act with the best interest of the child in mind. So it wasn't a formal incorporation of the statute into the law, but it was in effect a judicial imprimatur. There's also a statutory provision that came into effect around the same time that also talks about the need to take the best interests of the child into effect. So we would expect in the following years, as lawyers begin to utilize that case precedent and statutory precedent, that the Convention on the Rights of the Child will also be of increased use in the UK. And then the other important thing is the other treaties which have not been formally incorporated or haven't received that sort of judicial imprimatur, very, very few references to ICCPR, CEDAW, or CERD. So we're starting to see a trend that is confirmed when we look at the data from Canada. And so Canada, again, we have well, first of all, we have more utilization of treaties earlier on in the 1990s, and this is because there was, frankly, a concerted effort by the lawyers to start to inject these treaties into their advocacy. But the other thing is that, for example, the pink line, which is the ICCPR, that was, in effect, informally incorporated into Canadian law because as part of the Canadian Charter of Rights and Freedoms, it explicitly says that it must be interpreted according to the principles of the ICCPR. So that was a way in which that particular treaty became part of domestic law. But of course, that drops off around 2000. In part of it is, I think, also that learning effect where, again, the international norms are utilized extensively by judges as well as lawyers early on, and then it tends to drop off. But also what happened is you can see the green line, which is the Convention Against Torture. The use of that increased, particularly around shortly after 2000, because CAT was then formally incorporated and became part of Canadian law in 2000. Okay, and after that, then usage of CAT increased dramatically, and lawyers started to use that in torture cases as opposed to the ICCPR. The other treaties where we saw at least some use, and again, this is indicative in terms of, or telling in terms of the literature on this, on utilization of treaties. The yellow line, again, the Convention on the Rights of the Child. Canada had a similar case to that ZH Tanzania case. It's called Baker versus Canada. That came out, that was decided in 1999. And again, similarly said that when courts are looking at cases where children may be affected by the decision to deport the parent, the best interests of the child have to be taken into account. So again, judicial imprimatur on the Convention on the Rights of the Child. And then the blue line, which is the Convention on Discrimination Against Women, has been utilized since about the late 1990s, and that's because of some administrative rules that were passed in Canada that said in determining asylum cases filed by women, references should be made to guideline, or the CEDAW should be used as a guide in determining whether or not someone has a valid claim. So then the lawyers started utilizing CEDAW. So what we're starting to see in terms of a conclusion here, particularly when we look at the other treaties which aren't utilized very much at all. There we have the Racial Discrimination Treaty, hardly utilized at all. And again, has not been formally incorporated into Canadian law, has not received any kind of judicial or administrative imprimatur. So what we're starting to see and conclude with this is one of the most important factors in determining whether or not a treaty is going to have any utilization for lawyers as well as for courts is if it has been incorporated into domestic law, because then the judges are more comfortable using it in their decisions, relying on it, etc. Without that kind of either formal incorporation or the informal judicial imprimatur, treaties are not going to be utilized much at all, even though they've been ratified. So ratification is almost meaningless. What's more important is incorporation. Now, I haven't even made a chart with the US because I'm not sure how we would graph this, because there are virtually no references to any of the treaties in the study in the US other than the Convention Against Torture. That gets used all the time. So there's like 10,000 of those. And then literally in the single digits on most of the other treaties. So that would be really difficult to graph. So I'll just tell you what the numbers are. But again, that suggests that that's consistent with our overall conclusion, because CAT is part of US domestic law. Okay? And so therefore is utilized all the time by lawyers, and including some of you probably in your asylum cases. But the other treaties have not been incorporated either formally or through any kind of precedent by the US Supreme Court or any other federal courts. So again, the important thing is incorporation. But the charts here only tell a small part of the story. The more interesting question is whether the trends and references have been any good for asylum seekers. Okay, so in Canada and the UK, we see more utilization of treaties. In the US, hardly any. So if you look at the asylum grant rates in each of the countries, one might think the conclusion is somewhat counterintuitive. The blue line is Canada. Their asylum grant rate has been gradually decreasing over the last 20 years, from almost 80% to under 40% now. Similar trend in the UK. It was close to 90% of people applicants got asylum around 1990. It's now not much over 20%. And in the US, in contrast, the rate has been going up and is now around 50%. A bit ironic, because the two countries, as we've seen, where human rights treaties are much more a part of the jurisprudence, the asylum success rate has gone down, as opposed to the US, where there is not much reliance on those treaties, the rate has gone up. Now, there is obviously not a direct cause and effect between those things. There's a lot of factors that go into asylum grant rates, but I just thought this was interesting in terms of showing, giving an overall picture of where the asylum rates are going in each of the countries. Now, the other thing that we've started to do then, as I mentioned, we've coded these cases. And so we haven't just counted those references, because of course there are different types of references. So what we've done is we've coded each of those references according to how the treaty was referred to. And so we found 7 different categories. And the first 3 are the ones that we see most frequently. The court relies on the treaty in rendering its decision in favor of the asylum seeker. So the treaty was the reason for granting either asylum or other form of protection. Okay? That's the most helpful type of reference. On the other hand, many cases, and this is the largest category, the court rejected that argument, rejected the treaty-based argument, and rendering a decision against the asylum seeker. So that's a situation where the treaty does not help the asylum seeker. The other relatively large category is where the court used the treaty not as the basis for the grant of asylum or protection, but to buttress a grant of asylum on other grounds, and usually the Refugee Convention. But they also would allude to another type of treaty. The other categories we didn't see very often, except the last one, where the court mentioned the treaty but didn't analyze it. In other words, it acknowledged that the lawyers mentioned it, but just just ignored it. So, and the others, we just didn't see very many of them, but we coded them that way because they appear occasionally. That is, the court cites the country's violation of the treaty in analyzing the country conditions. The treaty's referenced in dissenting opinion, or the court says the treaty, the country doesn't recognize the validity of the treaty. So these are the coding categories. So then what we did was we looked at basically the percentages in each country for each of those references to determine, all right, how often, for example, is the treaty relied upon in granting asylum in each of the countries. And this becomes telling in terms of how useful the treaties are. So as you can see, in each of the countries, the most frequent use most frequent reference to the treaties is when asylum is denied. It's only occasionally used to grant asylum. And so, but it's interesting to see which treaties are relied upon in granting asylum. In Canada, most of the references in support of a grant asylum were to the Convention on the Rights of the Child. Why? We surmise this is because of that Baker versus Canada case, where the Canadian Supreme Court gave its official imprimatur on saying you've got to consider the best interests of the child in determining whether or not someone should be permitted to remain in Canada. And that was the basis for the grant of protection in several cases. In the UK, over 15% of all of the references were in situations where the court relied on the European Convention on Human Rights. And again, that's the one that offers broader protection either for torture victims or for the right to people who are asserting the right to a family life. In the US, the only way that one of the treaties is used as the basis for granting protection is under the Convention Against Torture. Again, that is the only treaty in the study that has been incorporated into US law. You can see that there's a sizable percentage of cases in each country where the treaty is used to buttress a grant of asylum on other grounds. And then the only other category with any sizable references where the court just completely ignores the argument. So obviously that doesn't help the asylum seeker either. But again, this is more evidence that when treaties matter when countries incorporate them into their domestic law in one way or the other. Then what we decided to do in terms of trying to better understand and look at trends over time in each of the countries is we divided those 7 categories that I discussed recently into basically two set. We collapsed it into 2 categories. References that help asylum seekers, and that would be situations where the treaty was used as the basis for a grant of asylum or where it buttressed a grant of asylum on other grounds, or where it didn't help. It was a non-helpful reference. And those are situations where the treaty argument was rejected, or it was just simply ignored. And here we can see that the country where treaties were most likely to be helpful to asylum seekers is the UK, and the treaty where they were least likely to help asylum seekers is the US. Okay? But again, in each of the countries, the vast majority of references are in situations where the treaty was not helpful to the asylum seeker. So then what we wanted to do is see, okay, what is the trend over time? Because remember, we're looking at this over a 20-year period. And so we looked at this for each country, and the story is different in each one. In the UK, and here we just started in 2000, you can see that on the horizontal axis, and that's because remember that in the UK there were hardly any references to treaties at all prior to 2000 when they passed the Human Rights Act. And the solid line are the non-helpful, the solid line is the helpful references, the dotted line is the non-helpful. So again, you can see the vast majority of references are not helpful to the asylum seeker, but over the course of the last decade, the percentage of helpful references, that is situations where the treaty was the basis for asylum, have been going up, whereas the non-helpful references, that percentage has been going down. So a somewhat optimistic picture. And particularly when, remember, the asylum grant rate in the UK has been going down. So at the same time that the overall grant rate has been going down, the number of helpful references to treaties has been going up, which would suggest, we have to do more statistical analysis of this, but it would certainly suggest that the treaties are playing an increasingly important role in UK jurisprudence and actually are having an effect on state actors, that is, the judges who are deciding these cases. In Canada, the reverse trend seems to be happening. And here we can go back to 1990, because if you remember from that earlier chart with the colored lines on it, that treaties have been referenced in Canada pretty regularly for the last 20 years. And here, the solid line, that is the helpful references, has been going down, whereas the unhelpful references have been increasing to the point now where there's about a 90 to 10% split. Why the difference? One is that perhaps this idea of the fatigue has been setting in. In the UK, it's still a relatively recent phenomenon to rely on the treaties, just 10 years, whereas in Canada, it's been going on for a longer period of time, and the judges may be starting to become more immune to these human rights-based arguments. The other point, and this has been documented in several studies, is that the Canadian judiciary has become much more conservative over the last half decade or so under the Harper administration. And that seems to be finding its way into judicial decisions on asylum. The U.S. Situation is in some ways a combination of both, in that, like the UK, helpful references, that is the solid line, were a bit on the rise in the early part of the 2000s, but now have started to decline in the latter part. But again, most of these references are to the Convention Against Torture. Okay. Now we wanted to look at a couple of other factors that we thought might have some impact on whether or not treaties are helpful or not helpful to asylum seekers. One of them is who's making the decision. Is it that administrative tribunal that I mentioned earlier, or is it the appellate court? Because a common theme among the attorneys that we've interviewed, at least in Canada and the UK, is that federal court judges, the appellate judges, are more sophisticated. They're more willing to engage with human rights arguments than the administrative judges, who are not as experienced. They have a higher caseload. They can't be bothered with human rights-based arguments. So what we did was we cross-referenced the type of reference to the treaty with who is making the decision. And we see here that the results are kind of mixed and somewhat surprising, particularly given what the lawyers were saying. Because in Canada, you're actually, the tribunals provided a helpful reference in a case 19% of the time. Whereas courts, the appellate courts, provided those helpful references only about 12% of the time. So in some sense, the lawyers are more likely to achieve success with the human rights-based argument when they're arguing before the tribunal as opposed to the appellate court. In the UK, it's the reverse, more in line with what the lawyers suspect. 22% of the time, the references from the tribunal were favorable to the client, whereas about 26% of the time they were unfavorable to the client. And the US, similarly, no, actually the US is more like Canada in that the tribunals are somewhat more likely to provide a helpful reference, that is 10% of the time, helpful reference to the treaties, than courts, which were likely only about 6% of the time to provide a helpful reference. So again, the results here are mixed in terms of whether or not the tribunal versus the court are more likely to engage a human rights argument in a way that helps the client. The other variable, and this is the last one, that seems to have some impact on the ways in which judges refer to human rights treaties, is the gender of the applicant. There have been studies showing that female applicants tend to have an easier time getting asylum than male applicants. And there are various theories for why this is the case. Women are seen as less threatening generally. They tend to be seen as more credible by judges. So we wanted to see, well, does the same trend hold with respect to the kinds of references that judges offer or judges provide in their decisions? And we found that this is the case. Now, because we're still compiling the gender data, we had to exclude CAT thus far from this analysis. But this is for all of the other treaties. And what we found was data that's consistent with the idea that the success rate for women is higher. And so what we found, for example, in Canada, that the likelihood of a helpful reference in a decision for a male applicant was about 22%, whereas that same likelihood was 40% for women. So women almost twice as likely to receive a helpful reference to a human rights treaty. By the way, both means in some cases men and women file a joint application for asylum, typically when a child is involved. And so that's why that category is there. In the UK, the difference is not quite as drastic, but again, women more likely to receive a helpful reference to a treaty than men. 21.5% for men, 27.8% for women. And the same holds true.
But for both.
For both, it's high. I know, that's really interesting. And we have to look, yeah, not sure about that one. So we have to look into that. Although the number is small, it's only 30 cases. So the N in the both category in the UK is rather small, so that may skew those results a bit. And the numbers for the U.S. are very small also because, again, we're not, the Convention Against Torture was not figured into these into this analysis because we haven't finished that coding yet. So the U.S. numbers are a bit small to draw any conclusion, though they are consistent with the idea that women are more likely to receive a helpful reference to a treaty. So, a few conclusions, and then I'll wrap up with these in terms of implications for U.S. lawyers who are active in this area. And especially because, and I think this is especially because formal incorporation of human rights treaties by the U.S. government is very, very unlikely, certainly under the current political climate. So what that would mean for U.S. lawyers is to take a different approach, but one that is informed by what the lawyers and the refugee lawyers in the UK and Canada have been doing. And that would be to integrate human rights-based arguments into their cases based on the experience in these other countries. Because that's how decisions like Baker versus Canada and ZH Tanzania come about. And the lawyers in Canada and the UK in interviews described this as, in the UK it was banging on. You keep banging on about these treaties and how they're applicable in a particular case. And you have to, you lose some of those arguments, but eventually, because of the facts of your case, because the judge is sympathetic, whatever it is, you will create some precedent that says that in future cases, judges have to take into account the best interests of the child, for example, in determining whether or not asylum or other type of protection is warranted. So you have to keep banging on, or beating a dead horse is the other way it was often described by the lawyers, particularly in Canada. But it has to be done artfully because many US judges will scoff at the idea of even being asked to consider a human rights-based argument when they are adjudicating an asylum claim, particularly if it's based on a treaty that the US has not incorporated into its domestic law. In fact, many of the judges will react in ways that was kind of suggested by that cartoon, where they'll see those arguments as desperate. So what my recommendation would be not necessarily to argue that the treaty itself justifies asylum or other kinds of protection, not that category 1, but go for category 3, which is the buttressing argument, that you back up your main argument, which is usually based on the 1951 Refugee Convention, but you back that up with an argument that says that this conclusion is also supported by the Convention on the Rights of the Child. That might be tricky since the US hasn't even ratified it, but it's supported by the ICCPR or CEDAW or one of the other treaties. And the other lesson from the data is lawyers shouldn't underestimate the creativity, or at least the willingness of some administrative judges to engage with human rights-based arguments, and they may be sympathetic to that. I think it's also important to take into account the data on gender, and that as a general matter, judges, including in the US, are generally more amenable to treaty-based arguments when the applicant is a woman as opposed to when the applicant's a man. So it would suggest that in making arguments for the applicability of a treaty, particularly if you're trying to put forward a test case, that it would be best advanced when the applicant is a woman because you might have a better chance. So overall, it's important for lawyers in the US to be strategic, but in their use of these treaties. And the experience in Canada and the UK show that short of informal incorporation, really the only way for human rights treaties to make a difference is to get the imprimatur of the highest court. But that can only be done through creative litigation that utilizes the treaties in a way that judges are comfortable with. So that's it for the presentation, and I welcome your questions, comments, thoughts, and ideas for explaining some of the data that we've seen. The other thing that I'll mention that your question suggests is which cases end up in written decisions, because that's important too. Okay, as to the first question you asked, most of the questions that are going to be appealed are denials. Okay, so you're already in a situation where the court below has decided negatively, and perhaps in the course of that decision offered a not helpful reference. Okay? The government can appeal a grant of asylum, but as a general rule, most of the appeals occur where there's been a denial below. So that could affect the data. The other thing that affects the data is that, for example, in Canada, the tribunal judges are not required to give a written decision in cases where asylum is granted, unless it sets some kind of a precedent. They are required, however, when asylum is denied. The idea being, look, if you're going to deny somebody asylum, you better explain it so they have a means to appeal it. Okay? So what that means is the database, you're starting from a database that has more negative decisions in Canada. UK isn't exactly like that, except that the tribunal only issues written decisions in situations where, again, the cases of precedential value or what they call country conditions cases. And that's where the tribunal decides, okay, in this case, we're going to determine what the conditions are like in Somalia, for example. And then that will set a precedent for other folks who are seeking asylum from Somalia or Ethiopia or whatever it is. And that, of course, can change as conditions change. But anyway, that country condition case gets published. And then the other ones that get published in the UK are cases that the tribunal itself decides have precedential value. Whether those tend to be more negative or not, that's a little bit hard to say, although at least one judge has told me that when they're denying asylum, that's when they really want to be careful and really make sure that the analysis is tight. And so that's when those cases are more likely to be published. The other thing to bear in mind here that I didn't mention earlier is when we talk about, there can be more than one reference in a single case, because of course the lawyers may invoke a few different treaties on behalf of the same client. So references are, the number of references is higher than the actual number of decisions. The other thing that we have to track, and we have not yet, but we will, is that some of the references are to the same case, but at different stages along the way. So you might have some references in a case involving a particular client at the tribunal, and then also on appeal. And that could affect this also in terms of, because what the goal is determine, are these variables, whether it's the level of the court, the gender of the applicant, we're also going to look at the gender of the judge, and the country of origin. Are those statistically significant, or are they in some cases, in some sense, just random? And so we have to get into the statistic. Right now, we're at the point of likelihood and showing those kinds of percentages, which suggest that there may be some statistical significance to these things. But that's what the sabbatical is for, is going into more depth on that. In terms of the first thing, we have not looked at the role of domestic statutes in the cases that we're looking at. Part of that is just because that would involve a whole nother variable and a lot more coding of particular law. I think the assumption is that, and this is based on what the lawyers say, to the extent that there is domestic law that would govern a particular situation, the lawyers are going to utilize that and the judges are going to rely on it. So I think if we did track that, we would show that there would be many more references and much more reliance on the domestic law. But I'm sure that if we documented that quantitatively, that's what the data would show. And your point about the UK situation, sort of more looking to international law generally, is very well taken, and in part because of it being, at least for now, in the EU. Although, as you probably know, there's debates about, well, there's always been a debate in the UK about whether to stay in it, and that's been intensified recently. But yes, I mean, there's this, and one of the questions I asked the lawyers is, because there's been some suggestion that in the UK in particular, lawyers see themselves as kind of on a global stage. and that their decisions are going to be read and scrutinized by judges, by academics, by lawyers in other countries. And does that make them, in some sense, more expansive in their attitude towards human rights law? And I've gotten a mix of responses on that. I'd say the majority think that certainly British judges have often seen themselves as sort of leaders in this area, and that they have to, that they're setting a tone. They know that other countries are going to, maybe not follow their lead, but at least listen to what they have to say. So that I think that plays a role in some of the statistics, and also their membership in various conventions like the Dublin Convention, et cetera, certainly do. So they just have more of that mindset. But it's interesting, and again, I think that chart where we had the big increase after the European Convention became part of UK law, that there's still this hesitance among a lot of the judges to refer to anything but British law and in jurisprudence, and so. The other thing that they said, this relates to the point about at which level the court, at what level the decision is being made, because they said at the higher reaches of the judiciary, they're much more expansive and forward-thinking when it comes to these things. So, but I think they start at a different point, certainly, than judges in the U.S. I mean, the interesting thing in the U.S., I have to tell you, more than one lawyer in the U.S. who I interviewed about this, and these were prominent lawyers who do this kind of work. When I asked them about using international human rights law, they said, "Oh, that's interesting. Maybe you should do a seminar on it and tell us how to do it," because it's just not part of the landscape. But for good reason, because the judges have not shown much receptivity to it at all. But again, I think there may be an opening for that based on what we're seeing in the other countries. And we do have those figures. I didn't make charts of them. Our assumption was what you had said. Well, that it's going to be more pronounced in situations where women's rights are at stake or something like that. But we've seen it across in each of the treaties. It seems like it almost doesn't matter what the substance of the claim is in terms of the probabilities that we're seeing, which is seeing across the board, which that might support the idea that, well, women are just seen as more credible, regardless of what the claim is, and less threatening. And so they're going to have an easier time getting protection, but also the argument, the human rights-based arguments, are going to have more traction when they're used on their behalf. That hasn't come up in our data. I've seen that anecdotally in some of our cases where we're representing clients in Minnesota, particularly in the case of Liberia, where that's a situation where there have been, there are reports that conditions are improving. So it's harder to make the argument that if this person goes back, they're going to be subject to persecution. But the situation where, at least according to the lawyers that we've interviewed, where it can actually hurt is, as they say, as a couple of lawyers in the UK have said, when you over-egg the pudding. One thing that's great about this project, by the way, is all the expressions that you learn and become familiar with. That's one of my favorites. So over-egging the pudding, you just, throwing in too many arguments. The problem that they see is it can obfuscate your stronger argument. And in addition to giving the impression that you're kind of desperate, you're throwing in the kitchen sink, and the judge just throws up his or her hands and says, "Okay, forget it. I'm rejecting this claim." So that's a way it can hurt. But it can also, again, it can obscure the stronger claim. So that's actually a concrete way in which it can hurt. It's also really interesting, the interview process here, because I'll ask that question. Almost everyone says, "No, I don't think it. Why would a treaty ever hurt?" And then it's sort of like in a deposition, which, if those of you who've done them or have trained, you leave a little silence, and then they'll sort of add a little more. And they always say, but on the other hand, I did have one situation where, usually it's not anything, of course, they've done. They've seen others do it. And maybe they've been in the courtroom or something like that. And then they've seen a situation where there's been the over-egging of the pudding and too many arguments, and they can see that the judge gets aggravated by that. And it can result, again, in some situations, rare, but in some situations of a denial. Now, that might be able to be remedied on appeal, but who knows? Yeah, sure.
Real quickly, Steve,
yeah.
And have everyone quickly thank you. You have the room for a few more minutes, so feel free to continue your questions, but I know some people have to leave, so.
Oh, yeah, if anybody has to leave. Oh, thank you. Thank you. Thanks for your